The Valley Current.
Imagine waking up tomorrow morning. You roll out of bed, you shuffle into the kitchen, and you start the coffee maker.
Yeah, pretty standard morning.
Right. You haven't checked your email yet. You haven't looked at the news. You haven't even taken that very first sip of coffee.
Yeah.
But in the time it took you to just wake up, you already owe someone an additional $2,787.
And that is, that's just the interest.
Exactly. Just the interest, not the principal debt, just the daily penalty for that debt existing every single day, Monday through Sunday.
Holidays included.
Holidays included. It's the kind of math that physically makes your stomach drop, you know?
Oh, absolutely. It's terrifying. But the crazy part is this isn't some hypothetical nightmare scenario.
No, this is the staggering documented reality right now for one of the world's most prestigious, highly resourced law firms following a massive jury verdict. We are talking about a $25.4 million judgment. And today, we're going to figure out the exact anatomy of that staggering number in this deep dive. Like, how does an elite firm, backed by some of the sharpest legal minds on the planet, find itself bleeding nearly $3,000 a day in interest alone?
It is a fascinating and frankly terrifying case study. And to unpack it, we're using a really incisive piece of source material. We are looking at issue 1 of a newsletter series. It's titled Big Firms, Big Matters, Big Fees, Big Screw-Ups.
Love that title.
It's so blunt, right? It's published by Jack Russo and the Entrepreneur Law Group, or ELG for short, and they've just done an incredible job laying out the mechanics of this entire dispute.
Yeah, the title alone gives you a sense of the scale we're dealing with here. Our mission today is to dissect the case of Gregg versus Cooley LLP, but, we aren't just here for the courtroom drama.
Right.
Although, to be fair, there is a lot of it.
Oh, tons of drama.
But we're looking at this as a cautionary tale for you, the listener. It is a masterclass in what happens when extreme business complexity collides with really rushed, high-stakes deal-making.
Well, and before we jump into the numbers, I do want to set a very clear baseline for our conversation today. We are going to explore this entirely impartially.
Right, very important.
Because this is a story with two incredibly strong competing realities. A jury made its decision, yes, but Cooley LLP is appealing the verdict.
They're fighting it.
Exactly. They strongly, fundamentally disagree with the outcome and the way the facts were interpreted by the jury. So our job today isn't to play judge or jury. We aren't here to take sides.
No, we're just laying it all out.
Right. We are going to present the established facts, the contested allegations, and maybe most importantly, the industry-wide structural issues that this case exposes, exactly as they are detailed in the ELG newsletter.
Okay, so let's unpack this. Because to truly understand the gravity of the story, you first need to look at the final receipt. Like, why is this specific case making such massive headlines in 2026?
It all comes down to the math.
It does. On July 27, 2026, in the Superior Court of New Jersey, a total judgment was entered against Cooley LLP for $25.42 million.
Massive.
Right. But here's the part that made me do a double take when I was reading the source. The original jury verdict, like the damages they actually awarded back in October of 2025, was only $15.65 million.
Yeah, there's a near $10 million gap between the damages the jury assessed and the final judgment the judge actually ordered a firm to pay.
Which is wild.
It is. And that gap, it's entirely a function of time. We're talking about a litigation timeline that spans 9 brutal years.
9 years.
Yeah, from the initial complaint filed in 2017 all the way to the final judgment in 2026.
Hold on, let's slow down on that for a second, because the idea of a lawsuit taking 9 years is just mind-boggling to most people. How does a single dispute drag on for almost a decade?
Well, when you're dealing with high-stakes corporate litigation, 9 years is, it's long, but it isn't unheard of.
Really?
Yeah, you have to understand the sheer machinery of a massive lawsuit like this. You don't just file a complaint and then get a trial date the next month.
Right. It's not like traffic court.
Exactly. There are years of discovery, and in corporate law, that means millions of pages of emails being reviewed.
Ugh, sounds miserable.
It is. And then you have dozens of depositions where lawyers interrogate witnesses for 8 hours a day, then motions to dismiss, summary judgment hearings, appeals on random procedural issues before the trial even starts.
Just grinding everything to a halt.
Completely. It grinds the gears of the justice system to a crawl.
And while those gears are grinding, the meter is running. A $15 million verdict effectively turned into a $25 million judgment just because the calendar kept flipping.
Yeah.
Our sources actually break down this added cost, which they call a surcharge, and it amounts to a 62% increase over the base verdict.
62%. Just let that sink in.
It's crazy. It includes $3 million in attorney's fees, $1.16 million in litigation expenses, and a staggering $5.57 million in prejudgment interest.
Yeah, that interest is the real killer.
It's like a financial ticking time bomb where the litigation process itself becomes a secondary punishment.
Ticking time bomb is an incredibly apt way to look at prejudgment interest. Let's look at the underlying logic of that because it's important.
Okay, yeah.
Prejudgment interest is designed to compensate a plaintiff for the time they were deprived of their money.
Okay.
So the legal theory goes like this. If you suffered a financial injury 9 years ago, the money you lost could have been invested.
Oh, I see.
Right. It could have grown in the stock market or been put into a high-yield savings account or maybe funded a completely new business.
So the court is basically saying to the defendant, you didn't just lose the principal amount, you lost a decade of opportunity.
Precisely. So the court calculates a daily interest rate, which in this case is that $2,787 a day you mentioned at the start, and they just tack it onto the final bill.
Wow.
So when you have 9 years of highly complex, heavily fought litigation, the financial risk of taking a dispute all the way to a verdict fundamentally transforms.
Because you aren't just betting the principal amount anymore.
No, you're betting the principal plus a decade of compound interest.
Okay, but what about the fees and expenses? Because anyone who watches legal dramas or, reads the news has probably heard of the American rule.
Right, yeah.
The idea that in the U.S., everybody pays their own lawyers, win or lose. So why is Cooley footing a $4 million bill for the plaintiff's legal costs here?
That is a crucial nuance, and it's where the specific legal precedent in New Jersey comes into play. The ELG newsletter actually references a landmark New Jersey Supreme Court case called Saffer v. Willoughby.
Saffer v. Willoughby.
Yeah. In New Jersey, if a client successfully sues their attorney for legal malpractice, the courts have carved out a specific exception to that American rule.
Interesting.
They establish that the client can recover the reasonable attorney's fees and costs that they incurred in bringing that malpractice lawsuit.
What's the logic behind carving out that exception specifically for lawyers?
Well, the logic is that the legal fees are considered consequential damages of the malpractice itself.
Okay, walk me through that.
Think of it this way. If your lawyer hadn't made a mistake in the first place, you wouldn't have suffered the loss.
Right.
And you absolutely wouldn't have had to go out and hire a second lawyer to sue your first lawyer just to get your money back.
Oh, wow. Yeah, that makes sense.
So the cost of that second lawyer is a direct, unavoidable consequence of the first lawyer's failure. So, under the Saffer precedent, the plaintiff is made whole by shifting that cost right back to the defendant.
Man, that dramatically compounds the jeopardy for any law firm operating in that jurisdiction.
Huge jeopardy.
And we should probably give some context on Cooley LLP here, for anyone who doesn't know. Because we aren't talking about a small corner office operation that made, like, a clerical error.
Not at all.
The reporting in the ELG newsletter notes that Cooley is a massive elite entity. They are a top 15 AmLaw 200 firm.
Let's define that for a second for the listeners. The AmLaw 200 is an annual ranking of the 200 largest law firms in the United States, typically ranked by gross revenue.
Okay.
Being in the top 15 of that list, that means you are at the absolute pinnacle of the legal profession.
Right, and the numbers back that up. In fiscal year 2025, Cooley generated around $2.4 billion in revenue.
Jillian, with a B.
With a B. That was up over 10% year over year, too. We're talking about an institution with something like 19 offices globally and 1,400 lawyers.
Which tells you that they have the absolute best resources, the most sophisticated conflict checking software, brilliant legal minds.
They're the gold standard.
Exactly. They are trusted by the biggest tech companies and venture capital funds in the world. And yet, this incredibly complex, high-stakes collision still happened.
Which perfectly brings us to the human and financial core of the dispute. Like, how did a founder and $1 billion law firm end up in a 9-year war?
Right.
To figure that out, we have to trace all that $25 million math back to a single, incredibly painful check.
The infamous check.
Yeah, a check for exactly $6,670.
This is where the story shifts from abstract math to a very visceral human experience.
Totally. So let's introduce the plaintiff. John Gregg was the founder and CEO of a company originally called LifeQual Pharmaceuticals.
Which later changed its name to Symbiomix Therapeutics, yeah.
Right. And it's important to note, Gregg wasn't just like a business guy who brought a spreadsheet to the table. He was the inventor of the company's core asset, a drug called Solosec.
He was the absolute lifeblood of the company's intellectual property. The entire value proposition of the startup was built around his invention.
Okay, so he's the guy.
He's the guy. And this leads us to what the newsletter describes as the squeeze.
The squeeze.
Yeah. This is a phenomenon that happens frequently in the startup ecosystem, actually, but rarely with this level of subsequent legal fallout.
So walk us through how a founder goes from inventing the core product to getting squeezed out of his own company.
Okay, so in 2013, Gregg was terminated from the company he founded. Now, as part of the early stage financing of the company, he had signed something called a restricted unit agreement, or an RUA.
With who?
With the venture capital firms that had invested in the company. Those firms were OrbiMed Advisors and Fidelity Biosciences.
Okay, pause right there. What exactly is a restricted unit agreement?
Yeah.
Because just the word restricted sounds like someone else has control.
That's a great way to look at it, actually. When a founder starts a company, they usually don't get all their equity free and clear on day one.
Really? Even if it's their company?
Nope. Because investors want to ensure the founder sticks around and works hard to build the company. They don't want you taking their money and moving to a beach.
Fair enough.
So the founder's shares are subject to vesting, meaning they earn them over time, usually over a 4-year period.
Right, vesting. I've heard of that.
Yeah. So a restricted unit agreement outlines the terms of that equity, and crucially, what happens if the founder leaves or is fired before all the shares have vested. It gives the company, or sometimes the investors directly, the option to repurchase those unvested shares. And usually, they get to buy them back at the original extremely low purchase price.
So it's basically a contractual leash.
Exactly. It's a mechanism to ensure that if a founder leaves early, they don't walk away with a massive chunk of the company they aren't helping to build anymore.
Okay, that makes sense in theory.
In theory.
Yeah.
But in this case, the mechanism was used as part of a highly contested termination. When Gregg was ousted, OrbiMed and Fidelity exercised that repurchase option aggressively.
Meaning what?
Meaning they repurchased 28% of Gregg's shares.
And the price they paid for over a quarter of the company he founded. Exactly 1 single cent per share.
1 penny.
$0.01. So his total payout for 28% of his life's work was $6,670.
You can just imagine the psychological toll that takes on a person.
Unimaginable.
But it's the aftermath of that penny a share repurchase that sets the stage for the massive damages claim against the law firm. Because the story didn't end with Gregg's termination.
No, it didn't.
Eventually, those same venture capitalists sold Symbiomix for $150 million.
$150 million. And from that massive 9-figure exit, John Gregg, the guy who invented the core drug, received exactly $0 for that 28% chink they took back.
Nothing. And that contrast is where you really start to feel the sting of the dispute. It forms the entire basis of Gregg's lawsuit. Because Gregg's complaint argued a very specific damages theory. He claimed that the shares they took from him for $6,000 were actually worth over $1 million at the exact time of the repurchase.
Okay.
Furthermore, he argued that had he been able to keep them through the ultimate sale of the company, they would be worth over $9 million today.
Now, I know you want to make a very careful distinction here based on the newsletter's framing of this.
Yes, I want to emphasize the strict boundaries of our source material here. The ELG newsletter is meticulous about distinguishing between an established fact and a contested allegation.
Very important difference.
Crucial for understanding how the legal system processes a narrative. The fact that Gregg was ousted, the fact that his shares were repurchased for a penny each, totaling $6,670, and the fact that the company later sold for $150 million, those are established facts.
No one disputes those events occurred.
Right. No one is arguing that.
But his valuation of what those shares were actually worth, that's a different story.
Completely different. The idea that his repurchased shares were intrinsically worth $1 million at the time, or $9 million later, is his damages theory. It is a contested allegation.
Right, because Cooley would heavily dispute that valuation.
Absolutely. They would argue, perhaps, that the shares were properly valued at a penny at the time due to the high risk of the early stage venture. Or they might argue that the $150 million exit was entirely the result of the VC's subsequent work and capital injections, not Greg's early contributions.
And this is a great moment to look at how juries actually function in these highly complex corporate trials. Because John Gregg didn't go into this lawsuit asking for $9 million.
No, he didn't.
He went in demanding over $108 million in damages.
Which is just a staggering number.
Massive.
But the jury didn't just rubber stamp his demand. They listened to his theory, they looked at the competing valuations, they evaluated the complex financial realities of startup equity, and they rejected that astronomical demand. They didn't give him $108 million, they awarded him $15.65 million.
They also specifically declined to award any punitive damages. Can you explain the significance of that for us?
Yeah, punitive damages are a separate category of money awarded to a plaintiff, but their purpose isn't to compensate the plaintiff for a loss.
What are they for then?
Their purpose is to punish the defendant for conduct that is deemed intentionally malicious, fraudulent, or egregiously reckless, and to deter others from doing the same thing.
So it's like a fine on top of the damages.
Exactly. So by declining to award punitive damages, the jury essentially said, we believe Cooley committed malpractice and caused financial harm, but we do not believe they acted with malicious intent or outright fraud.
I see.
It was a failure of the standard of care, not an intentional plot to destroy the founder.
Okay, here's where it gets really interesting, though. When you look at the granular breakdown of the jury's findings, there is this bizarre contradiction that the newsletter highlights.
Oh, this is the wildest part of the case.
Right, so the jury found that Cooley LLP, the firm is a corporate entity, had an attorney-client relationship with John Gregg personally, and that the firm breached its standard of care.
Yes.
But the lead attorney on the account, a partner named Christian Plaza, the jury found that he did not have an attorney-client relationship with Gregg, and they totally exonerated him.
Yeah.
Judgment was entered in Plaza's favor. So how on earth does an entire law firm commit malpractice when the lead lawyer doing the actual work is found completely innocent?
It is one of the most fascinating quirks of this specific verdict, and it speaks volumes about the complexity of institutional representation at major firms.
Seriously.
Because the law isn't always perfectly intuitive. While the lead attorney, Plaza, might have been found not to have personally crossed that specific threshold into forming an individual attorney-client relationship, a law firm of Cooley's size is a vast web of interacting parts.
Right. It's not just one guy sitting in a room with the client.
Exactly. There were other attorneys involved over the years, some of whom were actually dismissed from the case via stipulation before the trial even began.
Oh, interesting.
But beyond the individuals, there are institutional mechanisms. There's advice dispensed by the broader team, emails sent by junior associates, firm-wide policies, collective strategies.
So the jury is looking at the whole picture.
Yes. The jury essentially concluded that the collective actions, the environment, and the institutional structure of the firm created a de facto personal relationship with the founder, even if the primary point of contact managed to successfully defend himself against personal liability.
Man, that feels like an absolute nightmare for firm management.
It is.
You can successfully clear the individual partner in court, but the logo on the door still takes a $25 million hit.
It's a massive wake-up call for risk management committees everywhere.
Which brings us to the core of the issue. How was this squeeze actually executed on a legal level? Because looking at the human toll isn't enough. We have to look at the machinery behind it.
Right.
It all comes down to a tangled web of allegiances and financial incentives.
Because while the squeeze sounds brutal on a human level, the jury was tasked with looking at how it was executed legally and ethically. And the core structural problem here is something that happens constantly in the startup ecosystem.
What's that?
It is the incredibly thorny issue of concurrent representation.
Let's map this out, because it is crucial to understanding the whole case. Cooley was acting as the legal counsel to the operating entity, right? The company itself, LifeQual, which became Symbiomex.
That is undisputed. The company was their client.
But as we just discussed, the jury found that Cooley was also concurrently representing John Gregg, the individual founder, at the exact same time.
And this is where the tension becomes unmanageable. Because while supposedly representing both the company and the founder personally, Cooley was actively negotiating a massive, complex financing deal against the venture investors, OrbiMed and Fidelity.
Right, the VCs.
These are the very same investors who eventually gained board control through this financing and engineered Gregg's termination.
But the newsletter points out There's another layer to this, which elevates it from just a tricky situation to a catastrophic one. They call it the billing conflict.
This is huge.
While Cooley is doing all this high-stakes negotiating, they have over $500,000 in legal fees that are contingent on this venture capital deal closing.
$500,000 on the line.
Right. If the deal doesn't close, they might not get paid. And who holds the ultimate veto power over whether the deal closes and those fees get paid?
The venture capitalists.
The very same venture capitalists they are negotiating against.
This is where we have to talk about the concept of fiduciary duty, because it is the absolute bedrock of the legal profession.
Okay, lay it out for us.
A fiduciary duty is the highest standard of care recognized in law or equity. When a lawyer has a fiduciary duty to a client, it means they have an absolute unyielding obligation to act in that client's best interest.
Above everything else.
Yes. And crucially, that obligation must sit entirely above the lawyer's own financial, business, or personal interests.
Okay, I want to create an analogy here because concurrent representation and fiduciary duty can sound very, abstract to the listener.
Let's hear it.
Imagine you hire a real estate agent to help you buy a house. You trust them. You think they are fighting tooth and nail to get you the lowest price and the best terms.
Right.
But then, deep into the negotiation, you find out their $500,000 commission isn't being paid by you. It's entirely controlled by the seller.
Oh, wow. Yeah.
And the agent only gets that massive paycheck if you agree to every single one of the seller's terms.
That changes the dynamic completely.
Who is that agent really working for in that scenario? If you ask them, hey, is this a bad deal for me? How hard are they going to fight the seller when the seller's holding their paycheck?
That analogy captures the tension perfectly. When a law firm's $500,000 receivable is riding on a venture deal closing, the firm's financial incentive is heavily weighted towards speed.
Getting it done?
Exactly. It's weighted toward getting the document signed, smoothing over disagreements, and keeping the people with the money, the VCs, happy.
Right.
So if raising a red flag on behalf of the founder, say, telling him, hey, John, this restricted unit agreement gives them total power to squeeze you out, if saying that might blow up the deal, the firm's fiduciary duty to protect the founder is placed in direct, irreconcilable conflict with its own financial reality.
And the jury clearly believed that conflict tainted the advice given to Greg.
Absolutely. And what's vital to understand here is that the ELG newsletter labels this a structural pattern in venture-backed founder disputes.
It's not just Cooley.
No, this isn't just a one-off mistake by one rogue firm. This dynamic, a firm representing the startup, dealing with a founder who thinks the firm represents him too, all while trying to close a deal funded by VCs who dictate the terms. This happens every single day in tech hubs around the world.
Wow. So we have the jury's conclusion and we see the massive financial penalty. But trials are essentially battles of competing realities, right? We need to look at how two sides looked at the exact same events, read the exact same emails, lived through the exact same timeline, and saw completely different truths.
It's fascinating.
The newsletter lays out the dueling narratives neutrally, at full strength, and it's so interesting to see how they clash. Let's start with Cooley's defense.
So Cooley's position is heavily rooted in the formal documentation. And honestly, this is exactly what you would expect from a top-tier law firm. They build their defense on paper.
Right.
They point to an initial engagement letter from 2009 and at least 6 subsequent agreements signed over the years, all explicitly stating in writing that Cooley represented only the company, not Greg individually.
Wait, 6 agreements?
Yes. That is an established fact in the record. The documents exist.
Wow. They also note that Greg acknowledged, again in writing, that he had the opportunity to get independent counsel to represent his own personal interests and chose not to. Furthermore, Cooley argues that Greg wasn't some naive kid fresh out of a college dorm room building an app. He was what the defense termed an exceptionally sophisticated party.
He was.
He was a founder, a board chairman, a seasoned executive who was navigated complex financing documents before. He knew how the game was played.
And perhaps their strongest piece of paper was the 2013 separation agreement.
Let's talk about that.
This is critical. When Greg was ultimately terminated, he didn't just walk out the door empty-handed. He signed a comprehensive release of claims.
A release of claims?
Yeah. In exchange for signing that document, which specifically released unknown and undisclosed claims against the company and its agents, he received a standard severance package, a $291,000 cash bonus, and additional equity vesting.
$291,000.
Yes. Cooley's stance is unequivocal. They acted with professionalism and integrity. They have the ironclad paperwork to prove it. They strongly disagree with the verdict, and they are appealing.
Okay, I have to stop here and push back hard on behalf of anyone listening who operates in the real business world.
Go for it.
Because looking at Cooley's defense, it seems incredibly solid. If a highly sophisticated founder, a CEO of a biotech company, signs not one, but 6 separate legal documents stating clearly, "You aren't my lawyer."
Right.
And then at the very end, he signs a separation agreement releasing claims and takes nearly $300,000 in cash to walk away. Shouldn't he be held to that paperwork?
It's a very logical question.
What is the point of a contract if a jury can just ignore a mountain of signed waivers? Doesn't this verdict destroy the foundation of how corporate law operates?
It is a totally fair question, and your reaction is exactly why this case is sending shockwaves through the legal community right now.
I mean, it just seems crazy.
It feels counterintuitive to everything we are taught about contracts. To understand how the jury bypassed that mountain of paperwork, we have to look deeply into John Gregg's narrative, which the jury ultimately adopted.
So how did he overcome 6 signed waivers?
Gregg's position was that regardless of what the formal paperwork said in the fine print, the operational reality of the relationship was entirely different.
What does that mean, practically?
He argued that Cooley attorneys were giving him personal legal advice virtually daily.
So actions speaking louder than words. Or in this case, actions speaking louder than heavily negotiated contracts.
Precisely. Under the law, in many jurisdictions, an attorney-client relationship is not solely determined by a piece of paper with a signature on it.
Really?
Yeah, it can be formed implicitly through conduct. The legal standard essentially asks, did the individual reasonably believe the attorney was representing their personal interests based on the attorney's actions?
But how does a sophisticated CEO reasonably believe that when he signed a paper saying the exact opposite?
Because of the day-to-day interactions.
Right.
If a lawyer consistently answers your personal legal questions, if they advise you on your personal liability, if they help you strategize on how to protect your own equity position against the investor.
Which is what Gregg was claiming.
Exactly. If they are giving you strategic advice for your own benefit rather than just the company's benefit, a jury can look at that continuous stream of conduct and say, you are acting as his lawyer, period. You can't give him personal advice every day and then hide behind a waiver when things go wrong.
Okay, that makes sense on a practical level. Someone walks like your lawyer and talks like your lawyer, they're your lawyer.
Exactly. And Gregg layered onto that by arguing that Cooley never explicitly disclosed the $500,000 contingent fee conflict to him personally.
Right.
He alleged he was kept in the dark about the financial leverage the VCs had over the firm.
And then there's the most damning allegation regarding the actual drafting of the squeeze-out.
Right. Gregg alleged that when Cooley advised him to assign his most valuable intellectual property to the company without a clawback provision.
Meaning he couldn't get his IP back if he was fired.
Correct. And when they told him to accept a termination without cause clause in his employment agreement, they brushed his concerns aside. He claimed they verbally reassured him, calling these massive, life-altering concessions just a formality.
Oh, just a formality. I feel like those are the famous last words in any business negotiation.
They absolutely are. So to address your pushback about the contracts from earlier, the jury was asked to weigh 2 competing realities.
Okay.
On one side, the formal, written boilerplate contracts drafted by the lawyers to protect themselves. On the other side, the informal, daily, operational reality of the relationship. The daily phone calls, the personal advice, the reassurances that dangerous clauses were just a formality.
And the jury decided the informal actions overrode the formal documents.
Yes, they decided you cannot contract your way out of a fiduciary duty if your daily conduct creates one. This raises an urgent question for anyone in business. How safe are the verbal assurances you rely on every day? And conversely, if you are a professional, how protective is your boilerplate paperwork if your daily emails and phone calls contradict it?
It is a massive wake-up call. You can have all the waivers in the world, but if you treat someone like a personal client on a Tuesday afternoon phone call, you might just be buying yourself a fiduciary duty.
Which brings us to a really fascinating broader point. Taking a step back from this specific courtroom battle, the ELG newsletter proposes a theoretical framework for why these massive mistakes, these big screw-ups, happen at elite, highly competent, well-intentioned firms.
I found this part of the source material incredibly insightful.
Me too.
Breaks it down into math. The analytical framework they introduce is complexity divided by time equals cost.
Let's unpack the variables in that equation. They argue that in modern corporate law, the complexity of a legal matter is constantly rising. You have multi-layered corporate structures, complex intellectual property transfers, labyrinthine tax considerations, and incredibly aggressive venture capital term sheets.
So the complexity variable is through the roof.
Yes. But the time allotted to handle all of that complexity does not rise proportionally. In fact, it often shrinks.
Because everyone wants things done yesterday.
Exactly. Investors want deals closed immediately. Founders want the cash in the bank yesterday. So when complexity rises and time decreases, the total cost of the work skyrockets.
But that cost doesn't show up immediately on the monthly invoice, right?
Yeah.
It's a deferred cost.
Exactly. When you apply this equation of error to the Gregg case, you see it perfectly. You have parallel negotiations of highly overlapping, dense agreements.
Which agreements?
You have the company charter being rewritten. You have the proprietary information and inventions agreement, which dictates who owns the tech. You have the restricted unit agreement dictating the equity. You have the executive employment agreement. All of these incredibly dense, life-altering documents are being drafted, revised, and negotiated on a compressed, breathless, deal-closing timeline.
Because the venture capitalists want the deal closed by the end of the quarter, and the law firm wants the deal closed so they can finally collect their $500,000 fee.
So the speed goes to max, the time available for deep review drops to near zero.
And the complexity remains dangerously high.
Yes. And the ELG newsletter points out that the deferred cost of that rushed process wasn't paid at the closing table in 2013. It was paid 9 years later in the form of a $25.4 million verdict.
It is an incredible, painful irony. In trying to rush a deal to save time and secure a fee, the firm bought themselves almost a decade of agonizing litigation and lost millions of dollars.
And if we connect this to the broader industry landscape, it proves this is not an isolated phenomenon. The newsletter actually cites data from the 2025 EPIC Law Firm Group survey and commentary from ALPS Insurance, which provides malpractice coverage.
What did the data show?
The data shows that malpractice claim frequency actually rose in 2025 for the first time in years. And specifically, conflict of interest claims hit an all-time high.
Wait, an all-time high? In 2025, with all the technology we have, law firms have million-dollar enterprise software systems dedicated entirely to running conflict checks. How are conflict claims going up?
Because technology can only flag names in a database, it can't assess the nuanced reality of human relationships under pressure. The complexity of business relationships is outpacing the time professionals are given to analyze them. In a multi-party venture financing, the lines between the founder, the startup entity, the board of directors, and the incoming investors are incredibly blurry. Everyone is talking to everyone.
So when you compress the time frame for closing a deal from like 3 weeks down to 3 days, what breaks?
The first thing that gets sacrificed is the deep structural review of those blurry lines. The rush to close the deal is prioritized over clear, written, repeated disclosures and thorough conflict analysis.
Right.
A lawyer might think, I don't have time to write a formal memo clarifying who I represent today. I just need to get this term sheet revised by 5 p.m.
It's the systemic speed versus disclosure trade-off.
Yeah.
It feels like everyone in the startup ecosystem is running so fast across the finish line that they are violently tripping over the terms of the race itself.
And that deferred cost of mistakes doesn't just hit the law firms who have to pay judgments.
Who else does it hit?
It hits the founders who lose their life's work and equity. It hits the boards that get tied up in depositions for years instead of building products. The dispute itself becomes the ultimate devastating penalty for the initial lack of thoroughness.
Which brings us to the most practical and important part of this entire deep dive. How do you protect yourself from becoming the subject of a 9-year lawsuit? Whether you are a first-time founder, a seasoned board member, or just someone navigating complex business deals in any industry, the ELG newsletter provides a set of incredibly practical takeaways. We can call it the learner's playbook.
I love that.
It's a set of 5-pointed questions you absolutely need to be asking.
This is where knowledge becomes truly valuable, when you can apply it to your own professional life to mitigate risk. The newsletter advises founders and boards to ask these specific questions to their deal counsel, and they need to ask them long before any conflict or tension arises.
Let's run through them. Question number 1. Whose interests does the engagement letter actually say the firm represents? And more importantly, has that scope changed informally since signing without a new written agreement?
That directly addresses the actions versus contracts tension we spent so much time discussing. You need to know explicitly if the lawyer you are talking to on the phone every day actually represents you, the individual, or if they represent the corporate entity that might decide to fire you tomorrow.
Yeah, you cannot assume they are your friend just because they are friendly.
Absolutely not.
Question number 2. Is any part of the fee contingent on the deal closing or controlled by a counterparty? We saw exactly how the billing conflict blew up in the Gregg case. You have to know who holds the purse strings of the professionals advising you.
Absolutely. Because financial leverage can subtly or not so subtly alter the advice you receive. If your advisor only gets paid if you say yes to a bad deal, you need to factor that into how much you trust their reassurance.
That leads to the third question. Have you been told in writing to seek independent counsel?
And not just a casual, hey, John, you might want to run this by your own guy if you want.
Right.
It needs to be formal, documented, unequivocal advice. If things go sideways, you want absolute clarity on whether you are expected to rely on their advice or find your own.
Question number 4 goes back to the equation of error. Does the closing timeline actually match the complexity of the deal?
This is a tough one.
Are you trying to cram 3 months of legal structuring, IP assignments, and equity vesting into a 3-day weekend just to satisfy a venture capitalist's arbitrary quarterly goal?
That is often the hardest question to ask in the heat of a high-stakes deal, because no one wants to be the person slowing things down. Founders are terrified the investors will pull the term sheet if they drag their feet.
Of course.
But, as this $25 million case proves, slowing down for 3 weeks to get the structure right is vastly cheaper than litigating for 9 years.
And the final question from the playbook, which might be the most crucial red flag of all, are crucial terms, like your equity vesting schedule or your termination clause being brushed off verbally as just a formality.
That specific phrase should trigger massive alarm bells for anyone.
So what does this all mean for you, the listener? If you take nothing else away from this deep dive, take this translation into everyday business survival.
Yep.
If someone slides a contract across the table that strips you of your rights or forces you to give up your IP, and they verbally tell you that a legally binding written clause is just a formality, stand up and run the other way.
Or at the very least, hire your own lawyer to read it before you sign it.
I completely agree.
Right.
We highly encourage you to audit your own professional relationships and your own corporate documentation before a crisis hits.
As ELG points out so effectively, this conversation needs to happen before a closing, not after a dispute.
Right.
You need to clarify these boundaries when everyone is happy, when the champagne is flowing. Because once the squeeze happens and the relationship turns adversarial, it is far too late to figure out who was representing whom.
It is preventative medicine for your business. Because once that lawsuit is filed, you are on the hook for the time, the stress, the public exposure, and maybe a daily interest charge of $2,700.
And as we wrap up this analysis of the Gregg versus Cooley case, I want to leave you with a final thought that builds on the source material's warning about speed and complexity.
Let's hear it.
We are moving into an era where artificial intelligence is speeding up document drafting exponentially.
Oh, yeah.
We have software that can generate a 100-page contract in seconds. Business moves at literal lightning speed. But we have to ask ourselves, are we building a corporate ecosystem where the obsession with closing the deal fast is creating a massive invisible bubble of future legal liabilities?
That's a scary thought.
If a top-tier law firm with 1,400 brilliant lawyers and massive resources can stumble so disastrously over the line between formal contracts and informal advice, how safe are the verbal assurances we all rely on every day? It is something to seriously mull over the next time you are asked to quickly sign a complex document on a Friday afternoon.
A sobering thought to end on, but an incredibly necessary one. Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available, commitment-free, with no paywalls or other charges.
Tune in next time on The Valley Current.